Your lecturer is Molly Bishop Shadle. Professor Shadle is a professor of law at the University of Virginia School of Law, where she teaches negotiations and advocacy classes. She earned her JD from Columbia University. Professor Shadle clerked for Judge Eugene H. Nickerson of the U.S. District Court for the Eastern District of New York. She spent 4 years as a litigation associate with the firm Covington & Burling, and then joined the U.S. Department of Justice's Office of Intelligence Policy and Review, where she represented the United States on terrorism-related matters before the Foreign Intelligence Surveillance Court.
Imagine a courtroom in Florida in 1961. The setting is formal. Close to the entrance are rows of seats for the public and the media. In front of the public seating is a wooden railing, and behind that, 2 long tables. At one table sits a prosecutor and his team, lawyers. They know what they're doing. They've got legal training and all the power of the government behind them, and they are ready to try this case. At the other table sits a defendant, all alone. His name is Clarence Earl Gideon. He is a poor ex-con who has only an 8th grade education. He left home and went out on his own in middle school. He is accused of breaking into the Bay Harbor pool room in Panama City and stealing $5 in change, $50 from the jukebox, and some drinks. Mr. Gideon claims he's innocent. He can't afford a lawyer, so he asks the court to appoint one for him. And here's what the judge says. Mr. Gideon, I am sorry, but I cannot appoint counsel to represent you in this case. Under the laws of the state of Florida, the only time the court can appoint counsel to represent a defendant is when that person is charged with a capital offense. I am sorry, but I will have to deny your request to appoint counsel. So, with the odds stacked heavily against him, Mr. Gideon does the best he can to represent himself. The situation I'm describing to you is the basis for an important Supreme Court decision from 1963, known as Gideon versus Wainwright. We're going to examine it in this lecture the way law students would, but it will also serve as a touchstone as we consider the American legal system and the special role that litigation holds in it. We'll explore why we adopted the particular legal system we have in this country, how that system works, and why law is taught in America the way it is. Now, let me confess right now that litigation isn't a typical subject for a first-year law student to study. It is the stuff of upper-level courses. But learning about it offers a valuable orientation to the study of law generally. And I think you'll see the great value of acquiring legal skills, even if you have no plans to become a lawyer yourself. Let's start our discussion with the role of law in American society. It is fair to say that law and the idea of America are inexorably intertwined. America is a nation of laws. From the very beginning, the American experiment has grappled with the question of how much power the government should have over the people and the rules under which people interact with one another. When America broke away from England in 1776, it famously rejected the notion that a king gets to make those rules. Instead, the power of the government and of lawmaking belongs to the people. Although that idea is, of course, much more complicated than it sounds. Our Declaration of Independence proclaims, governments are instituted among men, deriving their just powers from the consent of the governed. The notion that the people are in charge was an extraordinary idea at the time our country was founded. And when you consider the number of authoritarian governments that continue to exist in other parts of the world today, it's still remarkable. Think about this, though. When our country was founded, the founding fathers were, in essence, breaking the law. They were rebelling against the British monarchy, which means they were committing treason in the eyes of England. How did they justify their actions? What made them different from a rioting mob? What gave them the right in their eyes to seize power? To make the case that breaking away from England was the right thing to do, the founders wrote the Declaration of Independence in 1776, explaining, when in the course of human events it becomes necessary for one people to dissolve the political bands which have connected them with another, and to assume among the powers of the earth the separate and equal station to which the laws of nature and of nature's God entitle them, a decent respect to the opinions of mankind requires that they should declare the causes which impel them to the separation. So they didn't just rebel, they explained why they were rebelling. They then replaced the legal system they were rejecting with a new one, starting with the U.S. Constitution, signed in 1787. And in that document, they limited the power of government, creating a system in which the people could undo everything if they wanted to. That's how the Founding Fathers made the idea of America legitimate. They created a legal framework and they wrote it down. They did what lawyers do. And we have continued to be a nation where people question the laws, challenge them, change them, and rely on them. Our nation is composed of people who quite often do not agree with each other. Every election cycle, we take some people out of power and put new people in charge. We rewrite the rules. But with the exception of our bloody Civil War, we haven't done it by means of armed conflict. We've mostly done it peacefully, by using our legal framework. That's really empowering. Regular citizens are able to be involved with the law, to influence the shape of the law, simply by voting or by raising a claim in court. Because of the importance of law to the functioning of our country, lawyers have long played a prominent role in American society. Alexis de Tocqueville famously observed in 1835, "When one visits Americans and when one studies their laws, one sees that the authority they have given to lawyers and the influence that they have allowed them to have in the government form the most powerful barrier today against the lapses of democracy." That influence continues. More than half of the 45 U.S. presidents have been lawyers. So are many members of Congress, most judges, and many prominent leaders in business and banking. Lawyers are involved in making laws, seeing that they're enforced, testing the parameters of laws, changing laws, and creating the business deals and other contracts that keep our society functioning. You will certainly see lawyers at work if you go to a courtroom. When you think lawyer, you may think Perry Mason or Atticus Finch. But lawyers are often the people who also lead large corporations or help them do business or merge with one another. Lawyers often run our various administrative agencies that govern things like taxes, the environment, the internet, elections, the financial markets. If you read in the news about a complicated issue that will impact a lot of people or involve a lot of money, there is probably a lawyer involved. Many lawyers have influence and power, but it's a kind of power that's open to anyone willing and able to go to law school and pass a bar exam. You don't have to be born into that power like a king. That's a pretty American idea, the self-made man or woman, and also a very democratic one. If you keep in mind the guiding principle of the United States that the power belongs to the people, not to a king, you can understand why we ended up with the legal system that we have. There are democratic principles woven throughout it. And so you can also see why the judge in the Gideon case sounded so uneasy about not being able to appoint Mr. Gideon a lawyer because the power imbalance felt really unfair. The judge even apologized to Mr. Gideon for not being able to do it. The Supreme Court, in its review of the Gideon case, described the problem like this. In our adversary system of criminal justice, any person hailed into court who is too poor to hire a lawyer cannot be assured a fair trial unless counsel is provided for him. This seems to us to be an obvious truth. In other words, without effective assistance of counsel, a defendant is unlikely to be a match for the power of the government that is prosecuting him. So why couldn't that Florida judge just appoint Mr. Gideon a lawyer if he wanted to? Here's why. The American legal system is a common law system and is derived from the English legal tradition. So some countries like France, Italy, and others in continental Europe have a civil law system. In a civil law system, written down rules called codes are the primary basis of the law. Judges in these systems interpret the code and make sure that it's followed, but their decisions have no lasting authority. They are not bound by earlier decisions of other judges, nor are other judges bound by theirs. Now, in our common law system, by contrast, written down laws, we call them statutes, and judicial decisions are both important sources of law. What a judge says about the law can be every bit as important as a statute, and sometimes more so. Yet our judges are also bound by statutes and by the decisions of other judges who have come before them. A common law system checks the power of the legislature, which creates the statute, because a judge gets to interpret it. And it also limits the power of the judge deciding the case, because he has to follow the rulings of previous judges. He can't just make up an outcome according to his own personal desires. The common law legal system is one of the ways that we limit the power of the government over the people in America. The law as established by judicial opinions is called case law, and case law really shapes the whole way we teach law in the United States. Until around 1870, American law schools were pretty informal. Law students attended lectures if they chose to, and they self-reported their accomplishments rather than being graded by a professor. After a year or two, they were awarded a diploma. There were no academic prerequisites for being admitted to law school, no required courses, and no exams. So it was probably less stressful than law school today, but the system also did not ensure that graduates had actually learned anything about the law. In 1870, Christopher Columbus Langdell became the dean of Harvard Law School. The next year, he published a book called A Selection of Cases on the Law of Contracts, in which he described law as a science. The best way to master that science, he said, was by studying the cases in which it is embodied. So notice that Langdell didn't propose that people learn the law by studying the Constitution, although there are certainly plenty of cases involving constitutional law to be studied. He didn't propose that people study statutes either. He proposed the study of judicial opinions, and appellate opinions at that. That gives you some idea of the significance of litigation and judicial opinions in the American legal system. In his classes, Dean Langdell began methodically questioning his students about the cases in his casebook, seeking to provoke active critical thinking in order to reconstruct the underlying doctrines. This particular technique of reasoning and arguing is now known as thinking like a lawyer. Langdell's mode of teaching is similar to one used by Socrates in ancient Greece, so it's known as the Socratic method. Soon, law schools all over the country were using Langdell's method. It's not the only way law school professors teach, but most professors in the first year use it to this day. It allows a single professor to teach large groups of students while providing those students with some opportunity to practice their verbal skills, a cost-effective model for a law school. And Gideon versus Wainwright is one of the cases law students are likely to be asked about during their first year. So back to Mr. Gideon's story. Here's how the common law system affected it. Because of the nature of our system, the state court judge presiding over the Gideon trial was limited by what other judges had said about the law. And at the time of the Gideon trial, there existed an old case called Betts versus Brady, which held that even though the Sixth Amendment of the Constitution guarantees a right to counsel in all criminal prosecutions, that right didn't necessarily extend to prosecutions in state court. Florida's system at that time only guaranteed a lawyer for cases involving the death penalty, which stealing $55 certainly would not. So the judge's hands were tied. But that put Clarence Gideon in a terrible bind because America's is an adversarial system. In an adversarial system, parties make their best arguments before a judge or jury, and from the conflict between them, the judge or jury determines the truth of what happened. The idea is that we're more likely to figure out the right answer if we hear the best arguments from both sides, and that in certain cases, we want a jury, representing the regular citizenry, to hold the ultimate power of deciding what that truth is. This is different from the inquisitorial system used in some civil law countries. In an inquisitorial system, the judge acts as an investigator in a case, questioning witnesses and interrogating suspects. In an adversarial system, the judge serves as an impartial referee, ensuring that the rules are followed, and the parties retain the power of deciding what evidence to present, which arguments to make, and whether to settle the dispute out of court altogether. The jury, representing the public, renders a verdict. Now, the jury is typically composed of everyday people, but they ultimately hold a lot of power in the courtroom. There are parallels here to America's view of government. We believe that democracy, which involves hashing out opinions in the marketplace of ideas, will ultimately lead to the best way to govern. Similarly, we believe that having both sides to a conflict present their best arguments to a judge or a jury will lead to a just outcome in court. But imagine navigating that adversarial system without the assistance of a lawyer, as Mr. Gideon had to do. The Supreme Court, reviewing his case, wrote, "Gideon conducted his defense about as well as could be expected from a layman. He made an opening statement to the jury, cross-examined the state's witnesses, presented witnesses in his own defense, declined to testify, and made a short argument emphasizing his innocence to the charge contained in the information filed in this case." Nevertheless, the court noted, the jury returned a verdict of guilty, and petitioner was sentenced to serve 5 years in the state prison. But that's not the end of the story. Mr. Gideon appealed his case. And this is another important aspect of our court system. To make sure that we get it right, we have layers of judicial review. Let me take you through them. Trial courts are the courts where cases start. We've been talking about a trial court so far in our Gideon discussion. At trial, both sides present evidence to demonstrate what happened in the dispute that brought them to court. They bring in witnesses and exhibits such as pictures, documents, a murder weapon. There is a judge who decides what evidence can be considered and whether the procedural rules are being followed. A trial can be decided either by a judge or a jury, depending on the type of case. Now, many jurisdictions have trial-level courts that hear a wide variety of cases. These courts are sometimes called general district courts. Some places have created specialized kinds of trial courts. For example, the District of Columbia has a landlord-tenant court, where judges hear only disputes between renters and their landlords. There's a benefit to this because the judges become very familiar with DC landlord-tenant law and are more able to apply it properly. A court system might have a specialized traffic court or a divorce court or a court for juveniles. As you may know, legal cases are divided into two broad categories, civil and criminal. Civil cases involve disputes between private parties. An example might be a lawsuit by a person who bought a car against the seller of the car when it turns out the car is a lemon. The person who brings a civil lawsuit is called the plaintiff. The person who is sued is the defendant. In a criminal case, a person is accused of breaking a criminal law. So if the person who bought that defective car decided to settle the dispute by burning down the car dealership, that person could be accused of committing arson, which is a crime. In that case, the person against whom the suit is brought is still called the defendant, but because a criminal law has apparently been violated, the person bringing the suit is a prosecutor and represents the state or federal government, depending on whose law was broken. If a party believes that something has been wrongly decided at trial, he or she may be able to appeal that issue to an appellate court. The issue has to be preserved for appeal, however, which usually means that the attorney has to flag the perceived problem during the trial by saying objection and indicating the nature of the error. And the appeal has to be filed within a certain time, usually 30 days after a case has been decided or a final judgment on the issue has been ordered. Remarkably, Mr. Gideon was able to do all this properly. He appealed his conviction to the Florida Supreme Court. So in an appellate court, there are no witnesses. The parties do not present evidence. There's also no jury. Instead, lawyers argue legal issues to a panel or group of judges. Appellate courts do not rehear all the facts of a case. Instead, they focus on the specific question of law that's being appealed to determine whether it was decided correctly. So the focus of a hearing before an appellate court is much narrower than an entire trial would be. If the trial court has made an error, the appellate court may overrule the trial court's decision and issue a written opinion about it. If a party disagrees with an appellate court decision, it may appeal to the ultimate judicial tribunal of a court system, typically known as a Supreme Court. That court may overrule or affirm the appellate court's decision and issue a written opinion about that. These are the cases that law students study, reported decisions by a court of appeals or Supreme Court. Typically, the written opinions worth studying in law school are the ones where a court has made a new interpretation of the law. Those decisions are actually pretty rare in everyday life, but they're what we focus on in law school because they are the most difficult and the most interesting. To further complicate things, America has both federal and state laws, and they are not always consistent with one another. What might be legal in one state might not be legal in another, and state laws and federal laws also clash on occasion. Since we have a dual system of laws, we also have a dual system of courts, federal and state. This system, again, has its roots in the American Revolution. The framers of our Constitution wanted to limit the power of our federal government. They recognized that we needed unity for purposes of strength in order to form a more perfect union, but worried about the dangers of a strong central government because of their experiences with the British monarchy. The framers also came from different states. They felt loyal to their states and knew that different states had different priorities and values. They wanted to permit room for the states to make their own laws, to preserve those different points of view. So, our Constitution gives certain powers to the federal government, but leaves other powers to the states and does not require the states to have laws identical to one another. Federal courts are courts of limited jurisdiction, which means they can only hear certain kinds of cases. They can hear cases that raise a federal question, which means the plaintiff or prosecutor has alleged a violation of the U.S. Constitution, a federal law, or a treaty. They can also hear cases involving disputes between parties from different states. So, if you have a lawsuit about freedom of speech, for example, you could go to a federal court because the suit involves an alleged violation of the Constitution. If you have a lawsuit in which a person from Alabama has bought a defective car from a person from Mississippi, you can go to federal court because the dispute involves parties from different states. But if you have a dispute about someone in Alabama buying a defective car from someone else in Alabama, you're going to be going to state court. About 90% of all cases heard in America are in state court. Both the federal court system and the state court system have trial courts, courts of appeals, and a Supreme Court or other court of last resort. The names of state courts vary from state to state and can sometimes be confusing. For example, in New York, the trial level court is called the New York Supreme Court. The appellate court is called the Appellate Division, and the Supreme or highest court is called the New York Court of Appeals. Now, federal courts, not surprisingly, employ the same names throughout the country. The trial court is called a federal district court. The appellate level court is a U.S. Court of Appeals. And the court of last resort is, of course, the U.S. Supreme Court. In addition to state and federal statutes and the case law written by judges, law also comes from constitutions, both federal and state, from treaties, and from regulations. Regulations, as you may be aware, are rules made by an agency at either the state or federal level pursuant to a statute. Sometimes laws conflict with one another. Perhaps a state legislature enacts a law that declares no one is allowed to talk about the color blue. That would be in conflict with the U.S. Constitution, which prohibits the making of any law abridging the freedom of speech. So which trumps, the state law or the Constitution? The Constitution trumps. But why? To answer that question, you need to know the hierarchy of sources of law. The U.S. Constitution is at the top of the legal heap. It sets up the whole system of law in America. What it says goes. The Constitution itself says so in Article 6, Section 2. This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. So from that, you can see that after the U.S. Constitution, what comes next in order of importance are the laws of the United States, which means federal laws, what judges have said about those laws, and federal regulations pursuant to those laws, plus federal treaties. State constitutions, state statutes and court decisions, and state regulations come under that. Regional and local ordinances would come after that. So if a state tries to pass a law that violates the U.S. Constitution, that law is invalid. And that is why you can talk about the color blue even if your state says you can't. Sometimes a case can begin in state court but be resolved in federal court. And that is what happened in Clarence Gideon's situation. His case began in a Florida trial court. He then appealed to the Florida Supreme Court, which denied his appeal. So Mr. Gideon petitioned the U.S. Supreme Court, handwriting his plea on lined paper that he got from the prison. And the Supreme Court found that his claim had merit. It held that the Sixth Amendment of the Constitution, which guarantees the right to counsel in a criminal case, applies even in state court proceedings like Mr. Gideon's. So that is an example of the Constitution, the highest law of the land, trumping what Florida state law said, and of the Supreme Court, a federal court, overturning the judgment of a state court. Gideon versus Wainwright also shows how important a lawyer can be. Here's how the Supreme Court explained it. That government hires lawyers to prosecute and defendants who have the money hire lawyers to defend are the strongest indications of the widespread belief that lawyers in criminal courts are necessities, not luxuries. The right of one charged with crime to counsel may not be deemed fundamental and essential to fair trials in some countries, but it is in ours. From the very beginning, our state and national constitutions and laws have laid great emphasis on procedural and substantive safeguards designed to assure fair trials before impartial tribunals in which every defendant stands equal before the law. This noble ideal cannot be realized if the poor man charged with crime has to face his accusers without a lawyer to assist him. The Supreme Court's decision in Gideon versus Wainwright expanded the right to counsel to all cases in which defendants are accused of felonies, that is, serious crimes. It continues to protect the rights of defendants to this day. That's one important reason why first-year law students still study it. They might be asked in class to explain why the case was decided the way it was, what the ramifications of the case are, what might happen if some fact of the case were changed, how the logic of the justice's decision worked, how the case is similar to or different from other cases the class is studying, and so forth. By thinking through these questions about Gideon and other cases, law students begin to understand not only what judges have said about the law, but why they made the decisions that they made. They acquire the knowledge to help people obtain the equal justice that Gideon promised. I hope you can now see why legal training is valuable well beyond the courtroom and the other places lawyers work. If you can think like a lawyer, you've gained valuable insight into how things get done in this country. And if you can think like a courtroom lawyer, then you are able to apply that knowledge quickly and use it to articulate your positions aloud. That's a valuable skill set for anyone to have, particularly in a representative democracy such as ours. Let me leave you with one last piece of the Gideon story. After the Supreme Court sent his case back to Florida, Mr. Gideon was tried again for the theft of the $55 and the drinks. But this time, he had a lawyer on his side. And that lawyer made mincemeat of the prosecution's only witness. Mr. Gideon was acquitted after the jury deliberated for only an hour. Now that's effective assistance of counsel.